Sure. So your question is regarding, so we've gotten this question before on lease agreements and the payment of the deposit, and people actually structuring the payment of the deposit as a suspensive condition. So, deposits will be paid. If the deposit is not paid, the contract is subject to that, and the contract will not come into being or will lapse or be null and void or whatever you want to call it through the failure of the payment of the deposit, right? Now, it is an unusual clause because normally we tie occupation to payment of deposit, but we've seen more and more of these in contracts where people don't quite understand the implications of conditions, be it resolutive or suspensive. So maybe just run through the difference and when they should be used and possibly when they shouldn't be used.
Okay, perfect. So let's just start out at a very high level. At a very high level, we're talking about conditions. Okay, and there are two kinds of conditions that are recognized within South African law. We have suspensive conditions and we have resolutive conditions. Okay, and the difference between these two is essentially that a suspensive condition is a condition upon which an agreement is formed when that condition is met. Okay, so there's a condition, something must happen before the agreement is comes into place. A resolutive condition is essentially the opposite of that, and that is upon the fulfilling of the condition, the agreement will come to an end. Okay, so these are the conditions are the same thing. You're waiting and specifying something must occur, but a resolutive and a suspensive condition, essentially what happens to the agreement is obviously the opposite of one another. One establishes the agreement, one brings the agreement to an end. Okay. Now, when you're relying on one of these conditions, generally you will have to put it in the agreement. It's got to be sufficiently clear, and it has to be an event, especially in terms of a resolutive condition, something that's actually going to happen in the circumstances. So you can't have a resolutive condition that something that the possibility of it not occurring is there. So the sun is going to fall down, because essentially that's going to be a contract which may never end, legally unenforceable in the circumstances. So generally this has got to be something that is foreseen, something that's actually going to happen in the circumstances. Now, where suspensive conditions are concerned, it's become very common practice to include suspensive conditions within lease agreements, where essentially the parties say that there's something has got to happen in order for this lease agreement to be considered valid and binding between the parties. Now, absolutely perfect. There are great examples of where suspensive conditions are used very carefully. I know for a lot of the bigger commercial landlords, they'll include suspensive conditions, for instance, that the lease agreement will only come into effect upon signature of the agreement by the landlord. Perfectly valid clause, and actually good protection for the landlord in the circumstances, because it means at the end of the day, the final say as to whether this lease agreement comes into place is theirs. From an enforceability in front of courts aspect, absolutely brilliant. It's a very very good way to convince a court whether lease came into place or not. And similarly, for the purposes of today's question, we've had a suspensive condition that the client has wrote us about, where they said that the lease agreement is not going to come into place until such time as the deposit is paid. And again, absolutely perfect suspensive condition that you can include into your contracts. What we want to warn about today is when you're using suspensive conditions, okay, you must be very careful about what you have included in your lease agreement, what you have included as a suspensive condition, because although it is a means upon which to protect perhaps the landlord in certain circumstances. So, for instance, if you have a suspensive condition that says the lease agreement is not going to come into effect until such time as the deposit is paid to the landlord. While that is intended to be a protectionary clause for the landlord, okay, so the lease is not going to come into place until such time as I've received deposit. So you're trying to make sure that the landlord has security at the point where the lease agreement comes into effect. It can also be a dangerous clause in the sense that if you don't keep your eye on that particular clause and you don't make sure that that suspensive condition is met, Okay. You sit in a circumstance where perhaps the agreement that you intended to have come into place isn't actually in place. So from an agent's perspective, you've got to be very careful. If you have a suspensive condition like that, that says the lease agreement is not going to come into place until a deposit is paid, but you decide to put a tenant into occupation of the premises before that deposit is paid, you end up in a situation where there is this now conflict because your tenant is in occupation of the premises, but technically, from a legal aspect, your lease agreement actually never came into place whatsoever. And you can't then enforce or rely upon the particular provisions of that lease agreement, say, to pay rent, okay, because the lease agreement itself never came into place. And your lawyer is then going to have to do a bunch of clever arguments to establish whether a tacit or implied lease agreement exists, which obviously we don't want to go down that road in the particular circumstances. So to round up this conversation, suspensive conditions, absolutely fantastic things, really good. The intention, obviously, to protect the parties and create a bit more certainty with regards to lease agreements, and that's brilliant. But you must keep your eye on the ball when you are using suspensive conditions. Make sure that you know exactly what is required by the parties. Make sure that you get those suspensive conditions out of the way and that compliance with those suspensive conditions is actually done. Because if you don't, they can also be very painful.
Thanks, Nick.